Assalamualaikum warahmatullahi wabarakatuh. We are from Group 3 and today we're going to talk about the defense in criminal law, specifically on the topic of accident. Before we continue with our topic, I would like to introduce our group members, including myself, Halina Hani binti Apazu alias Sami Hamzah, Nur Farahi Najaha binti Yusuf, Nur Alia Izzati binti Hamizi, Siti Zul Syafiqah binti Jamal, and Ain Nur Aina binti Iskandar Zulkarnain. The content for our topic, which is included with the issues, the law, the application and also the conclusion. Now, we will begin our presentation. I will pass this spotlight to the next presenter, Nur Farahi Najaha.
I am Nur Farahi Najaha. I will continue the presentation. The question that has been given is Analam was a drug addict. He used to buy drugs from Ahlan, a drug pusher. One day he went to see Ahlan to buy drugs. Both of them were at Kedai Cheng at Pulau Kentang when suddenly Ahlan received a phone call from another drug buyer, Xuan, who wanted to buy drugs. Ahlan asked Xuan to come to Kedai Cheng because it would be easier for him to prepare the drugs to the both buyers. However, the intended transaction had not taken place because Xuan did not bring along any cash. Ahlan became angry when Xuan mentioned that he wanted to take the drug first and would pay later. A quarrel sparked between both of them when Xuan said that he wanted to report to the police that Ahlan sold drugs to school children. Suddenly, Ahlan took a knife from his pocket and stabbed at Xuan's neck. Analam called for help and Ahlan was arrested for causing injury to Xuan. Ahlan claimed that he did not have intention but had accidentally caused injury to Xuan. The issue of this case is whether Ahlan may raise defense under accident for causing injury to Xuan.
Law. An accident is an unfortunate event resulting from carelessness, unawareness, ignorance, or a combination of causes. When an accident results in injury, the affected party may be entitled to relief under the law or to compensation under an insurance policy. Based on Section 80 of the Penal Code defines nothing is an offence which is done by accident or misfortune and without any criminal intention or knowledge in the doing of a lawful act in lawful manner, by lawful means and with proper care and caution. Section 80 of the Penal Code states that the act must be unintentional and pure accidental. It means that if a person does the act with intention to cause harm, therefore the person cannot raise the defense of Section 80 of the Penal Code. This section gives protection to anyone who performs an innocent or lawful act in an innocent or lawful manner from any unforeseen evil result that may ensue from accident or misfortune. Actus non facit rem nisi mensit rea are applicable in this situation, which means no act is per se criminal unless the actor did it with criminal intention. Moreover, the offence effect of Section 80 of the Penal Code, the act is still wrongful but law gives excuse to the accused. Hence, complete defense applicable to offender under the Penal Code or other statute. There are several conditions to succeed the defense under Section 80 of the Penal Code. The first condition is the act must be lawful in a lawful manner and the act must be done in a lawful means. The second condition to succeed the defense under Section 80 of the Penal Code is the accused person had exercised care or the accused person had exercised proper care or caution. There is a few elements of defenses that need to be fulfilled. Firstly, the alleged offence was caused by an accident or misfortune. A result is accidental when the act is done without intention, leading to misfortune. The accident is reasonable foreseeability of a low risk of occurrence. In Section 87 of the Penal Code, the act is not intended or known to be likely to cause death or grievous hurt and also done by consent. The second element is the act was not done with any criminal intention or knowledge. The criminal intent is the cause of doing an act forbidden through the criminal law without a reason or excuse. If the defendant did not intend to cause any harm, it will not be considered a defense but an accident. In the Penal Code Act 574, Section 81 explained that it is not considered an offence if the defendant did not intend to cause any harm to the person or property.
Thank you, Alia, for the presentation. I am Shafika and I will continue for the third element of the accident. The third element is in lawfully doing a lawful act by the lawful means. In order for someone to be covered below the defense of an accident, the act accomplished should be one this is lawful, done legally through lawful means and with proper care and caution. It has been performed very bound way, not in resistance to the law. The varieties of offences that are to be had are mala in se and mala prohibita. Mala in se or malum in se is described because of the acts which might be essential offences. It is a specific term that defines conduct prohibited by law, even though the distinction between the two classifications is indecisive. Crimes of mala in se consider a common law crime. For instance, rape, murder, theft, and cruel breach of trust. Next, mala prohibita, also called malum prohibita, means the act which calls for an illicit status after a restriction is compelled by the authorities. It is a behavior that is a criminal act defined by society, such as gambling. Next, the fourth element is the act was done with proper care and caution. Proper care or caution is defined as being careful, which the law requires the most, is sufficient if it is reasonable, such as in ordinary case. The amount of care and caution must be researched first as well judged. The reasonable matters will also be considered sufficient in all circumstances. Based on the case of State versus Ragaswamy v. 1952, the fact that two men were shooting wild rats in a jungle and the other person was shot dead by his companion, the court held that the possession of the gun was unlawful and constituted an offence under the Arms Act will not deprive him of the benefit of the immunity under Section 80 of the Penal Code because the act was done such as negative the existence of mens rea. Shooting is a law act and killing wild animals with a gun is killing it in a lawful manner by lawful means. Next, we go to the application of the law. In this case, Ahlan, a drug pusher, took a knife from his pocket and stabbed at Shin's neck after a quarrel sparked between both of them when Shin said that he wanted to make a report police towards Ahlan, who also sold drugs to school children. By applying to Section 80 of the Penal Code, there are 4 elements need to be fulfilled to constitute such act as accident. The first element is the alleged offence was caused by an accident or misfortune. In this case, the act of Ahlan stab at Shin's neck is not something simply happened in evil plight because the act of when Ahlan took a knife from his pocket and stabbed Shin's neck shows his intention to cause harm to Shin. Therefore, this element is not fulfilled.
Next, the second element is the act was not done with any criminal intention or knowledge. In this case, Ahlan pulled out a knife. Section 7 of the Corrosive and Explosive Substance and Offensive Weapons Act 1958 tells us that certain types of knives fall into the category of scheduled weapons, even if they are pocket-friendly and that the possession of this scheduled weapon is illegal. Therefore, the possession of knife may constitute Ahlan as having criminal intention due to the act forbidden by the criminal law. Therefore, this element is not fulfilled. The third element that need to be fulfilled is in lawfully doing a lawful act by the lawful means. In this case, the act of Ahlan took a knife from his pocket and stabbed Sean's neck shows he is not doing a lawful act by the lawful means. Therefore, this element is not fulfilled. The last element is the act was done with proper care and caution. In this case, the act of Ahlan is not a reasonable act because he may harm people. Therefore, this element was not fulfilled.
Thank you, Aina, for your astounding application presentation. Now I will continue with the conclusion. To conclude, Ahlan cannot raise defense under accident for causing injury to Sean as the elements of the defense is not fulfilled. That's all from us today. Thank you for spending your time and lending your ears. I hope we meet again soon. Thank you and Assalamualaikum warahmatullahi wabarakatuh.